Tara, you want to lead me in the pledge? Thank you. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much, Senator. Senate Judiciary is now in session. I'm calling up Lieutenant Chris Storm to introduce HB 482. Good to see you. I feel like I saw you Friday a lot. How are you? I'm doing well, thank you. You do have one of the perfect names, Storm, for being.
All right, well, let's see how it goes. So good afternoon. I am Lieutenant Chris Storm. I am a lieutenant with the New Hampshire State Police, and I am from the Office of Highway Safety. Representative Roy actually put this bill in for the Department of Safety, which we're hoping to increase the penalties for people traveling over 100 miles an hour. And I'll give you a little bit of a background. As traffic speeds on our roadways continue to escalate, New Hampshire State Police have reported a concerning rise in incidents of excessive speed. This trend necessitates the implementation of more stringent penalties to hold the most dangerous drivers accountable for their actions. Over the past few years, we have witnessed a steady increase in these alarming speeds, and it is imperative that we take decisive action to ensure the safety of all roadway users. We hope that you guys would be more than willing to endorse House Bill and pass House Bill 482 so we can work together to create safer roads and reduce reckless driving on our roadways. What I can tell you right now is a small sample size of what we're seeing out there. Just with our aircraft on the interstate system, we've seen over I can give you the exact number, almost a 200% increase, 230% increase in people traveling over 100 miles an hour just on the interstate system alone. And that's only with our airplane, not just necessarily our troopers that are out working on the interstate. And I thought Representative Roy was going to be here so I can tell you a little bit about the bill. Basically, all we're asking to do is increase the fine itself, and you guys saw the same exact bill that was brought forward here in the Senate that would increase the penalties as far as the fine goes to $750 and increase the license life from 60 days to 90 days on reckless driving for people over 100 miles an hour.
I think you covered it all. Any questions, Senators? Go ahead.
Thank you, Mr. Chair. Thank you for taking my question. Is this bill in any way different than what we sent over to the House?
It is
exactly the same?
Exactly the same.
Yeah, and we didn't muck around with it at all, right? No, okay. Thank you.
Thank you very much for your testimony. Anyone else wish to testify on 482 who didn't sign in, want to speak?
That would be me, I believe it was.
What's that?
Not that one.
Okay. Thank you very much, Lieutenant. Have a good day. And that'll end the hearing on 482. You want to go into exec and just kill this one off? Can we exec this one?
Sure.
Yep. Okay, I'm sorry. Or what?
Just curious if ours has already heard in the House,
It has, and it's coming up this week.
and if they make any changes to.
We can wait. I'll wait. Thank you.
Could I take that over?
I'm sorry.
That's okay. Thank you.
Lieutenant Storm, come back down. We had such a good time and it went so fast. Oh, no. Am I too early? Oh, okay. Do it all the same again and you'll be out of here in a minute. HB 776.
Good afternoon again. Again, I'm Lieutenant Chris Storm with the New Hampshire State Police, the Office of Highway Safety. HB 776, As everybody's seen, probably on the news and everywhere else, that we are having a tremendous issue with wrong way driving. Unfortunately, right now, if you are caught going the wrong way on our interstate system, it is not an aggravating circumstance to DWI, which is probably one of the most dangerous things that could be happening as a vehicle traveling up the opposing way coming at you when you're traveling at speeds at most times in excess of 65 miles an hour. So HB 776, which aims to add wrong way driving to the list of aggravated DWI offenses in New Hampshire. In recent years, we have witnessed a significant increase in wrong way driving incidents, with reports averaging nearly 1 occurrence per day on our roadways. And that documentation comes from our CAD system that comes into our dispatch through 911 of people reporting wrong way drivers on the interstate system. Many of these operators are found to be impaired by drugs or alcohol, posing a severe risk to themselves and others. By elevating the penalties for traveling the wrong way in violation of 265-26, which is the Controlled Access Highways statute, divided ways statute, while impaired by alcohol or drugs, to increase that to aggravated DWI. We can address this extremely dangerous behavior that frequently results in fatal collisions. Tragic cases such as those involving the fatal crash victim Lizzie Croak on Merrimack, in the Everett Turnpike, the Endicott Police Sergeant Jeremy Cole, and in recent multi-vehicle crash on Interstate 93 during a snowstorm, underscores the urgent need for stricter enforcement. These examples highlight the necessity for holding reckless and preventable actions to a much higher standard, ultimately aiming to enhance the safety of our roadways for everyone.
Thank you, Lieutenant. Any questions? Go ahead, Senator.
Thank you, Mr. Chair, and I apologize, I meant to look this up and I didn't. You probably know. Is there an aggravated factor added if you're not drunk or under the
No,
influence?
there is not. So if you're driving the wrong way, it is part of that statute, that 265-26, that is a violation level offense. There are other actions that we can take through the Department of Motor Vehicles for dangerous driving and so forth, but there is no aggravating circumstance right now for the DWI part of it.
Do you think there should be?
An enhanced penalty for wrong way driving on the interstate, we would. This is that progressive steps that we're trying to take to fix it.
Thank you, I appreciate it.
Thank you very much, Lieutenant. Go ahead, Senator.
Thank you, Mr. Chair, and thank you for taking my question. So it removes the violation level offense from 265-26, correct? Which, so
No.
it says the fine for a violation of this section is $150. But if we're pulling it over to 265A,
No, so if you're, no, so if you're.
walk me through that.
Yep, sure. So
Yeah.
if you're on the interstate system and you're in violation of that, or on a divided highway, that statute, if you violate that while you're under the influence of alcohol and or drugs, that will be an aggravating circumstance. So
Got it.
the reason that we use that statute, so if you were driving, say a person that was impaired took the wrong way down an alleyway or something like that, it's not necessarily an aggravating circumstance.
Got it. All right. Thank you for the clarification.
Thank you. And then if it's aggravated, we get increased loss of license for a longer time. For like
Yes,
the
it would
previous-
follow the same penalties as aggravated DWI. Yes,
Great.
Senator.
Thank you. Does anyone else wish to testify on 776? Seeing none, that'll end the hearing. We have 3 minutes, so get to know your neighbor. Representative Smith, Representative Lynn, good to see you. You're taking out 195, and I look forward to hearing it. Start when you're ready.
So, thank you, Mr. Chair and members of the committee. We both appear here in support of Representative Smith and myself. I'm Representative Bob Lynn from Wyndham, Representative Marjorie Smith from Durham. We both appear here in support of House Bill 195, which is, as should be obvious, a bipartisan bill that passed the House. This was similar to a bill, it was, I believe last year it was HB 314, which also passed the House and did not succeed in this body. We hope that there will be a different outcome this year. What I'd like to say, just briefly, and then I want to turn it over to Representative Smith's comments, is I think it's important to understand that this bill is a disclosure bill only. So unlike Senate Bill 255, which has now become law, which regulated first a broader range of businesses than this regulates, and Senate Bill 255 regulates not only disclosure of information, but the acquisition and other things. This bill has nothing to do with acquisition. It's limited completely to disclosure. And the importance of this bill as a supplement to Senate Bill 255 is that it provides greater protection against disclosure and it provides that protection as to a smaller group of entities than are covered by 255. Basically, this bill applies to things like credit card companies, insurance companies, utilities, service providers that typically collect a lot of personal information. And the main difference, the main additional protection that this bill provides is it requires an opt-in, a specific opt-in procedure to gain consent from someone if you want to be able to disclose their information. Whereas 255, it is essentially an opt-out kind of provision. This is a specific opt-in provision. The bill requires that the manner in which, or the procedure by which you seek to have the opt-in has to be like a separate request. It can't be something that's kind of buried, on the computer screen down in the corner. It has to be a separate request for disclosure, and we think that that's very important. And the other thing, and I think it's important to say this because I'm sort of anticipating some of what we may hear from other witnesses. I think it's important to understand that this bill allows disclosure under its terms for any legitimate purpose. And if you go through the terms of the bill, you'll see that there are exceptions allowing disclosure for any legitimate purpose. Basically, what this is designed to prevent is disclosure for illegitimate purposes or without consent. And so I think that's really about all I have to say about it. I'm sorry, there's one other thing I'd like to do if I could, and I'd like to present the committee with a proposed amendment. And I think what I want to ask you to consider is this. There was Representative McFarland in the House had proposed a floor amendment, which both myself and Representative Smith had talked about extensively, and we believed that it actually made the bill better. The problem was there was actually a communication lag between OLS and Representative McFarland, and so the version that came out on the day before we had to act on the bill was not drafted correctly. So this has, what I'm going to hand to you is a copy of what was agreed upon and what I believe quite firmly would have passed the House as an amendment. I think what we believe is that this amendment actually strengthens the bill and makes it better. But candidly, I'd have to say to you, I think it does that by sort of filling in the blanks. In other words, if your question to me was, is this amendment absolutely necessary? I would have to say, probably not. But I do think, I think Representative Smith also feels, that this does, by filling in the blanks, maybe making explicit what is only implicit in the language of the bill as it stands, it does make the bill better. And I hope that you'll think so too. And I hope that you will consider adopting the amendment. And what I would say is I have put, you'll notice the changes that the amendment makes from, proposed amendment makes from the original bill are in bold. So you'll be able to easily see what they say. And could I just pass this through your system? Thank you. And with that, I will shut up and turn it over to Representative Smith.
It's good. I'll let them both testify first. Yeah. Go ahead.
Does Senator have a question for?
We can do
Oh,
it
I'm
now.
sorry.
Sure, do it now if you want.
Thank you, Mr. Chair. I'm sorry to interrupt the flow. So in reading the bill, I was, and you mentioned it in your testimony, I was particularly drawn to page 3, lines 9 and 10, where it seems that we're looking for ways to tighten up our data, our information, so that it's not so easily accessible. And then in part A of section 2 on page 3, it says that the information can be provided if the government entity seeking the information requests that such notice not be provided and demonstrates good cause for making such a request. And then B is having a court order. So I'm wondering if part A is just really loose in that it doesn't create any barriers because any government entity can just ask nicely. Like, how do we, yeah.
Yeah, so you know what, I think the important thing to about that is, it's in that circumstance, the decision is not in the control of the government entity. It's up to the subpoenaed person to decide whether the demonstration, in other words, if I'm a police officer and I come to your business
Yeah.
and say, will you give me certain information, either with a subpoena or just making the request, and I say, listen, please don't disclose to the subject of, please don't disclose that information, and here's the reason why. You get to decide, is that good cause? It's not the government entity that gets to decide whether that's good cause. It's up to the business to make that decision. And of course, obviously, if I'm a police officer, for example, and I come and I say, I want this information, and I have a court order saying don't disclose, then there's no choice.
Right.
But if it's just a request, it's up to the business to decide whether they believe good cause has been demonstrated or not.
May I follow up, Mr. Chair?
Yes.
Okay, so just walking through that, the request is made without a subpoena, right? And so in this scenario, no subpoena, law enforcement is making a request, and the third party who has the information has 5 days to consider the request, correct?
Yes, that's right,
And-
yes.
And the determination of whether there is good cause is made by the holder of the information.
Right, exactly.
But we're not prescribing what good cause would be. It's up to the holder of the information to make that decision.
Right. I mean, I guess I would say, I think that, if, to the extent, for example, if a holder disclosed information and the the person that was the subject of the investigation, let's say, felt that that there was not good cause, that presumably could be a basis for a complaint to the Attorney General that there was an improper disclosure. And you know, if the Attorney General concluded that it had been disclosed improperly or withheld improperly, that presumably could be the basis for the Attorney General, say, taking some action in court.
May I follow up? So if the request is denied and the holder of the information who's denying the request says, I'm denying for good cause, do they have to meet the legal standard before they do that? Like, should it be prescribed so that, I mean, I imagine that if the information is denied, that the agency that's seeking the information is simultaneously within those 5 days seeking a warrant. So
I mean, that might be true. I would tend to think.
so this just slows down the process before a warrant is issued in most cases. Is that correct? Okay.
Right, unless the, as you saw that there's language in there that says, if there's a need for, there's a
Right.
need for speed, that they can't wait, then that's an exception. But if it's just, for lack of a better term, a exigent situation where there's time, then yes. Oh, sure.
Sorry, Representative Lynn. Does Graham Leach govern on a lot of this stuff and making this unnecessary, or am I wrong?
I think I don't profess in any way to be an expert on Graham Leach, but my understanding is that it would not apply. I mean, there might be some overlap, and that's why we have language in here saying if there's a conflict with any provision of federal law, then obviously we can't trump federal law. But my understanding is that there are that there's not anywhere near a complete overlap here.
Okay. Where it overlaps is going to add costs to these businesses. We'll say a national insurance company. Because then they're going to have these federal requirements they got to read. Now they have to have these state requirements. Is there an overlap that's going to cost businesses a lot of money?
Would they? I mean, I guess I would. When you say a lot of money, I mean, will businesses have to be more attentive to privacy interests, and to some extent, could that cost them money? Yeah, I suppose. Candidly, it could. I think that we believe that particularly given that we now have a privacy amendment in our Constitution, and the voters seem to think privacy is pretty important. That's a cost that's worth bearing.
Thank you, Representative. Go ahead.
Thank you, Mr. Chair. I'm Marjorie Smith. I represent Durham in the House. And I want to begin by saying we should not have to be wasting any time on these bills. Because if these bills were handled the way they should be, the federal government would have acted by now to set up national standards that were clear to everyone, both the people who want to protect privacy and those people who want to find out as much as they can about you. But the federal government has not acted. And that's why we are here. And it doesn't start here. As you all know, last year we were able to pass a bill that was a good bill and that came out of a lot of work between the House and then the Senate to move us along as well as we could be moved along in a small state to protect the privacy of the citizens of this state. So we are dealing with a situation that somebody else should have dealt with, but since they haven't, we have citizens of this state who expect us to step up to the plate, and that's what we are doing here. I want to focus on just one particular thing, and that is how do we know what is happening across the country? You know, there's been a lot of effort, and I know in the House we've gotten a lot of pressure, and I'm sure you will too, that we shouldn't try to do anything specific to meet the needs of New Hampshire, that we should just adopt what all the other states have adopted, which is a model that has been developed by those people who want to have access to information that we think should be private and that our citizens think should be private. But it was only relatively recently that an independent body, the Consumer Reports, completed a study on this very issue. And they said that companies may not be consistently complying with data privacy laws. They are not necessarily trying very hard to control our personal data, and they might not be complying with the law in any state. The Consumer Reports did a very involved study in which they able to come up with two conclusions, and the first is that compliance with data protection laws isn't assured, and that the second is that privacy laws are meaningless if they're not enforced. The government watchdogs have generally not done so. It's as though people regularly blow past your neighborhood speed limit and the police aren't doing anything. And this is a very real problem. Consumer Reports names particular agencies, and I don't feel and enterprises, I don't feel the need to do that here, although I can refer you to the study. And some firms honor privacy, even if your state doesn't have a clear law, but many firms do not. You all know, you look at something on the computer and then you go on to look at something else, and suddenly you're receiving ads. There are a lot of sneaker ads coming in there, or travel ads, or whatever. And clearly, it could be happenstance, but most likely it is a very specific, deliberate use of information that is private that was given to people. So states' privacy protections have been going on since 2018. And there are flaws in some of them that need adjustments. But after fierce corporate lobbying, laws have made it difficult for us to exercise our privacy rights. And this is one more attempt to try to meet the needs of the citizens of this state, citizens who very recently thought enough of privacy to pass a constitutional amendment. I hope that you will take this matter seriously and help us move along a road all designed to protect the privacy of the New Hampshire citizens. Thank you.
Go ahead, Senator.
Thank you, Mr. Chairman. And I'll direct this question to both of you. I see where it allows for the Attorney General to have exclusive action to enforce this. Was there any discussion or any thought on allowing a private right of action? I know there can be, a class action lawsuit that can be done privately as well, but this wouldn't permit that.
Yes.
I'm looking at the amendment.
Yes, I want to let Representative Smith to give her perspective also, but yes, there was extensive discussion about that Among the Judiciary Committee, there were different views. Eventually, we settled on not having this. I will note that this bill, the focus of this bill is the private entities that are covered by it, and there is no private right of action allowed here. The next bill that you're going to hear will be HB 522, that is directed at the state government. For that, there is a private right of action allowed, and I think that part, that sort of went into our thinking of what made sense in terms of appropriate compromises. That 522 would allow a private right of action against the state only, not state actors, but only against the state itself. And I think the House felt that was an appropriate compromise to allow it against the state, but not against private actors, not against private companies.
There's no need to say any more, I think.
Well, so if I can imagine if this is being violated, perhaps this third-party provider is doing it quite frequently, but if you have some, I guess, isolated, or I don't have a definition for how frequent, but if you have more isolated incidents, would that be something that would be a good use of the Attorney General resources? That's why I was thinking, if there was a private right of action, they still would have some recourse if this were to become law, but I don't know if you have any opinion on that thought.
Again, I'm as someone who personally, I have to say, I favored the conclusion of the bill of not allowing a private right of action against private companies, and I think one of the things that went into that thinking is a lot of these privacy protection things, including 255, which was just recently passed and does not allow a private right of action. We're dealing with regulations in a relatively new area, and particularly for private businesses, it seems to me that it's appropriate not to have a private action and to let this area of the law and these privacy things kind of develop. If we were taught, if this bill had been in effect for 5 years or something like that, and now the question was, should we now adopt a private right of action? Maybe the analysis would be different, because businesses have had a chance to deal with it now. They know what's going on, and it's less that they're going to be trapped by an innocent mistake.
Mr. Chairman, I began by strongly favoring private right of action. I did not, if there was a problem, the person who was feeling the pain of that problem should be able to take action. And it was only after weighing the specifics in this piece of legislation and the one that you will hear next that I began to focus on the difference between the adversary, if I could use that word, being a private corporation versus the adversary being the state. And it was clear to me that if you were to ask the Attorney General to be the sole arbiter, that would put that position in that office holder in a difficult position, because although I know and you know that the Attorney General is there to represent the citizens of the state, in fact, as that plays out, it gets a little confusing, and the Attorney General's office sometimes forgets that and believes that they are representing a state agency and not the people of the state. And so that supports, to me, the differentiation between whether we let the Attorney General play this role or whether there could be an individual right of action. And your concern that if it's only one or two cases, what will happen is a legitimate concern. And this is an ongoing problem. It is a very, very serious problem, and we believe that this state has always been cautious in how it moves. We passed a constitutional amendment, we passed legislation last year, and here what we're doing is trying to fine tune what didn't happen last year. It is not easy or simple.
Thank you.
Other questions? Thank you both.
Thank you very much.
I'm struggling with one name, Andrew,
Someone named Andrew.
who signed up. Then I won't get your name wrong. Okay, there you go. If you can just state your name and who you are.
Can you all hear me okay? Yes. Okay, great. Good afternoon. My name is Andrew Kingman. I represent the state privacy. I know my handwriting wasn't very good.
I was going to go with Kingman. He thought somewhere else.
I represent the State Privacy and Security Coalition. We're a New England-based organization that represents about 35 companies and 6 trade associations across a wide variety of sectors in the economy. I also have a background as a privacy compliance attorney helping counsel companies through various privacy laws throughout the states here. We're here today in respectful opposition to HB 195. Certainly believe that the sponsors are well-intentioned. Our concerns here are really that HB 195 is kind of trying to fit a square peg into a round hole that is the comprehensive privacy law, which passed last year. I know Representative Chairman Lynn mentioned that HB 195 is a disclosure bill only. The comprehensive bill that's in place in New Hampshire extensively regulates the disclosure of data from one company to another. But if we're going to talk about modifying that bill, we should do it within the context of that bill, using the same terms, the same types of data, et cetera. So SB 255 regulates disclosure in a number of different ways. It does establish opt-in consent for sensitive data. It allows consumers to opt out of the sale of their data. And that's very important because sale is very broadly defined as basically any transfer of data. And so when we talk about square peg round hole, HB 195 uses the term disclosure but doesn't define it. And so businesses are going to be looking at this saying, well, we have a definition of sale which covers this type of transfer of data. There's no definition for what constitutes a disclosure. How are they the same? How are they different, et cetera? The other critical way that that the comprehensive privacy law regulates disclosure is between the fundamental allocation of responsibilities between controllers and processors and third parties. So HB 195 uses the term third party in a very different way than the comprehensive law. The comprehensive law also regulates the transfer of information between controllers and processors. Controllers are really all companies that are consumer facing, that are determining jointly or alone with other the means and purposes of processing data. So they're the ones who are effectively collecting that data, deciding what's to be done with it. And then processors are entities that are performing various functions on that data at the direction of the controllers. And again, this is all very clearly and rigorously spelled out in the comprehensive bill. So trying to add separate requirements with separate terms that only apply to some types of companies and some types of data in a very different way really just is hard to square those two separate regimes. We also believe that this would be confusing for consumers. The Department of Justice and the Attorney General's office has formed their own data privacy unit to enforce this law and to help educate consumers. They're putting out frequently asked questions as we speak. I think the fact that the comprehensive law has only been in effect for about 3 months points towards seeing how that law is working before we try to add on to it, change it, tweak it with brand new requirements. But we believe it'll be confusing to consumers as well because this bill only applies to some types of information, and again, only applies to certain types of companies. And the comprehensive law is intended, other than information or companies that are already federally regulated, to apply to all companies comprehensively and to all types of data that are linked or reasonably linkable to an identified or identifiable person. And there are provisions in the comprehensive law that would directly conflict with opt-in consent for all forms of data, for all disclosures of data. And in particular, I want to flag what's called the universal opt-out mechanism provision in the comprehensive law. This is a provision that requires businesses to recognize a browser extension that consumers can download and put on their browser. And that browser extension directs the business to automatically opt the consumer out of the sale and the targeted advertising using their personal data. And again, that is an opt-out mechanism that is scheduled to come online next year. It's a relatively new technology. And it's actually that technology that the Consumer Reports study that was just referenced is specifically referencing. But that would conflict with a generalized requirement to opt into the disclosure, to any disclosure of information here. So again, this is sort of a square peg round hole where we're using different terms to maybe mean the same thing, applying it to some types of information that are already covered by the comprehensive law, applying only to certain companies that are either likely exempt under federal law or already covered by the consumer privacy law. So for those reasons, we believe that the bill should be voted in expedient to legislate, and I'm happy to take any questions.
Senator Abbas.
Thank you, Mr. Chairman, and thank you for taking my question. You said that some of these companies, I assume you were referring to the third-party providers, are already exempt under federal law. Which ones would be exempt?
What I was saying was the comprehensive law establishes, really determines the scope of who is within the law and who is without. So, for instance, a financial institution or data that is already regulated by Graham-Leach-Bliley to the earlier question is not part of the comprehensive privacy bill, because the rationale being Graham-Leach-Bliley already regulates the information and privacy controls for that type of data and for those institutions. And I believe the comprehensive law also exempts covered entities under HIPAA, under the federal health regime as well.
Thank you.
Thank
Sure.
you very much. Do we have other questions? Seeing none, thank you for your testimony.
Thank you.
Maura Weston. Good afternoon, Miss Weston. I hope your brackets fared well last night.
Excuse me?
Never mind. Basketball.
Oh, basketball. Not privacy, basketball. Mr. Chairman, members of the committee, thank you for having me. My name is Maura Weston. I am here today on behalf of the New England Cable and the New England Connectivity, and Telecommunications Association, NECTA, which is the regional trade association representing private cable and telecommunications companies in New Hampshire and several other New England states, including in New Hampshire, we represent Breezeline, Charter, and Comcast. Today, we are here respectfully in opposition to House Bill 195. With that said, our members have long been committed to protecting the privacy and security of their customers' personal information, and we were actively engaged in the conversations last year with 255 that resulted in New Hampshire RSA 507H. Our members comply with 507H, and as Mr. Kingman said, we would like to see this area of law develop as it was just enacted in January. The framework of 507H is well understood by the regulated community. Compliance is widespread, and it provides consumers with protections and actionable rights. This has been adopted in substantially similar form in about 20 states with stakeholder input. We believe that this allows consumers to receive the benefits of the technology economy while creating important rights. A few specific comments that, again, reflect our position that we should defer to 507H and what's already on the books. As Mr. Kingman pointed out, we have a lot of imprecise definitions, terms within the proposed bill that do not align with our current statutes. For example, HB 195 would require ISPs and cable television providers to obtain opt-in consent from consumers before disclosing or making available to any person a broad range of information. The sharing of information between our members and business partners can be anything from authentication technology to signing in and out of services to navigate across platforms or assisting with proper billing, for example. Also importantly, HB 195 seeks to protect individuals as opposed to consumers. This is an important distinction because a company, for example, couldn't disclose the names and addresses of employees, individuals, for purposes of payroll without first obtaining opt-in consent. Another specific example of an issue we have with the bill. Also, the term personal information is very broad and problematic in many respects. Again, 507H distinguishes between sensitive data, for example, genetic and biometric data, and non-sensitive data that's available from public sources, names, addresses, phone numbers. Also, vague terms. This uses, 195 uses the term location information. The term in 507H that's used is precise location data. Again, another example of inconsistencies and issues around vague terms. Moreover, the phrase available to the public as defined is really unclear. It really is subject to the individual's notion of privacy. And to make matters more confusing, again, there's a defined term in 507H, publicly available. 195 also conflicts with existing law. It would upend what we believe is a careful balance that was achieved in 507H by subjecting all personal information, regardless of sensitivity, to opt-in consent, potentially interfering with network operations and impeding digital commerce. It would stifle innovation. For example, another specific example, 195 does not include, it lists a range of entities subject to regulation, but it does not include search engines, satellite television, data brokers, et cetera. We believe that the much better approach is to work within 507H, what's on the books, and again, it's very clear and understood by the regulated community. In sum, we believe that HB 195 does not provide any additional benefits to consumers. We should give 507H time to work. And one additional note that I want to mention is that 195 contains certain enforcement provisions that we believe are law enforcement related provisions that we believe are unnecessary. And I'll defer to our written testimony that I submitted, but we have a good deal of information that we've submitted that demonstrates that law enforcement requests are already addressed under current state and federal laws. Additionally, NECTA members are required to communicate our privacy policies to consumers. Those are legally enforceable commitments. And as Mr. Kingman pointed out, that is subject to AG enforcement. So in conclusion, we recommend that, we ask that you recommend HB 195 inexpedient to legislate, as there are unintended and undesirable consequences. Thank you for your time.
Thank you very much, Ms. Weston. Any questions? Seeing none, thank you very much for your time.
Thank you.
And testimony. Lieutenant Steve McCauley. Good afternoon, sir.
My name is Lieutenant Stephen McCauley. I'm with the New Hampshire State Police. I'm here testifying neutral on this. Thank you for having me here today. Some of the concerns we do see with the language in 195 is laid out on page 3, lines 110 and 18, where it states that the government must show good cause or good cause, which is one of our concerns on who's actually deciding what good cause is. Is it the individual provider? It's not laid out clearly enough that I guess good cause could be decided by individual, depending on what provider we're talking to. That good cause definition could be different with each provider, which we do have some concern on that. So what is the individual definition of asking for a non-disclosure? It would be done through, if it is done through paperwork, it's done through the courts and judges and search warrants and such that would basically make that definition. On page 3, line 15, it talks about disclosure under multiple circumstances. The primary concern there would be under D and E, under basically the exigent portions of this. These circumstances are extremely fluid and oftentimes are extremely high risk situations, and disclosure of the items could mean someone's life is put at danger if it is disclosed. And again, we go back to the definition of good cause. What is good cause? Are we able to provide good? If we are asking for disclosure under exigency under D and E, and it's for an Amber Alert or abduction or a murder investigation that we're doing, is that good cause? I don't know, I guess. And if good cause was not found under that, whatever the definition of good cause is per the individual business, are they then going to disclose to the requester, which could result in really life danger, depending on what the actual investigation is. Furthermore, I just want to talk about page 3 and starting at line 3 on page 3, where it says, shall not require production of the information sooner than 10 days from the date or within 5 days, notify the individual. Again, it talks about the language where it says good cause requiring compliance more promptly. I guess going back to the language of good cause, who's defining what good cause is when it comes to this? If we need a subpoena serviced or we go to a provider and we ask for information and we do need it sooner because it's crucial to an investigation, we serve that grand jury subpoena, are they then going to go back to the statute and say, is it 10 days that we can't meet these demands within 10 days and then we have to notify the person within 5? Was good cause met? I guess it's just very confusing, and I feel that it's going to, good cause is going to be defined multiple different ways depending on the individual provider that you're speaking to, and it could cause, I guess, a great delay in investigations, as well as it could put people's lives in danger if notification is disclosed to the subscriber, if good cause, quote unquote, is not made by law enforcement. And that would be the concerns that we have with the statute as it, or the bill as it is laid out here.
Thank you very much for your testimony. Any questions? Yes, go ahead, Senator.
Thank you, Mr. Chair. Thank you for taking my question. I was right there with you with concern about the definition of good cause. But since the state police is neutral at this point, if you'll indulge me in looking at page 2, lines 1 through 3. If a request were being made by a law enforcement agency absent a subpoena, so this would be prior to getting a subpoena, and these things were met by saying to that third-party provider that there is you may not have the amendment, but there is a suggestion to put the word reasonably before the word necessary on line 2. So law enforcement had reason to believe that such disclosure is reasonably necessary to prevent, detect, protect against, respond to past, present, or expected criminal or fraudulent conduct, identity theft, harassment, deceptive or malicious activity. My first thought was Amber Alerts, right? While we're in the process of getting subpoenas, you want to be able to get as much information as possible to find that child. Would it be your opinion that this section B, and C that says an emergency exists where there's immediate danger of death or serious physical injury, that a situation like an Amber Alert would be covered there? Or should the language be a little bit more prescriptive?
I guess it's somewhat confusing because if you then go on page 3,
Yep.
where we start to talk about government entities, it then lays out that disclosure and such is going to be made. I don't have I have the one that was up there. So on page 2, line 1 and 2, the third-party provider of information and services has reason to believe that such disclosure is necessary to prevent, detect.
I think, Mayor, Mr. Chair, so the way I'm reading this, and if you're reading it in a different way, I'd like to see that through your eyes, is that there is an emergent situation, right? And there's an immediate assumed danger, right? And so law enforcement would be approaching the third party, and the third party is bound by this privacy lockdown, if you will, over the information, unless it is demonstrated to them that their lifting of that lock on the information would aid in the investigation of an emergency with immediate danger or death, which actually would qualify for an Amber Alert, right?
Right.
So I see there being an avenue for law enforcement to ask for the information and an avenue for that third-party provider to freely give that information without being in of this proposed law. Is that how you're seeing it, or what am I not seeing that you're seeing?
Yes, I do agree with you on that, on page 2.
Mm-hmm.
I guess it's more or less the disclosure that would happen. So I know it does lay out.
Sorry, disclosure by the third party
The third
or
party to the subscriber.
to the subscriber, okay.
So that disclosure is what could affect So in your example, an Amber Alert, let's just
Yeah.
say that an Amber Alert occurs because there's an abduction of a young child.
Yes.
And then we go to the third party, and yes, we do get the information from this and under the agency portion of this. But it still says that there has to be good cause demonstrated for the information then not to be provided, the disclosure then to be promptly provided to the subscriber, which then could be so that, in theory, that would be the person that we would have the Amber Alert, maybe driving the vehicle.
Gotcha.
And then that
Okay.
disclosure occurs, and I think that would make the case very, very difficult once that occurs, because, say if it's a cell phone, the cell phone then would be shut off or thrown away or destroyed, because now we made disclosure promptly that we requested information through the third-party provider.
So if we move down in page 2 to the disclosure section, if we look at line 29, part C, when compelled to do so by duly issued search warrant, does that not give the third party the out for not notifying the consumer?
As I read
And
it,
part E?
I do not think it does, just because
Okay.
where if we then follow up and go on to page 3 again, where we start talking about government entities, because it outlines those same, through search warrant, but then it says it should still be promptly disclosed. I guess page 3, line 15, 14 and 15.
May I, Mr. Chair? Okay, so we're on, I see where you are on page 3, and moving down from lines 15 through 19. Is there, in your opinion, is there space around the line 17, 18 area to tighten up not making that disclosure as pursuant to the investigation of a crime in progress?
Yes, absolutely.
I think that's the one space that we're trying to find
Absolutely.
some language to address that specifically. Okay. I think I understand where you're coming. Thank you very much.
Thank you, Senator.
Thank you, Mr. Chairman, and thank you for taking my question. I think you somewhat alluded to this. So there can be a scenario where you either, whether it's reasonably believe it's necessary or good cause, show, whatever the term we ultimately determine, you may think that you've reached that level of what's going to happen if you go to the third-party provider and they don't agree with you. So I guess in that scenario, how would you, in an investigation, how would that get worked out? I mean, would you have to go for a warrant, or I'm not really sure. And I suppose it could be the reverse. Even if they agree with you, I suppose a court or the Attorney General's office may not agree with you. Then what does that do to the third-party provider?
Absolutely. If we were in a situation, I guess, where so it'd primarily be under exigency, because if we were doing paperwork where we were doing search warrants or subpoenas, that type of language, I feel like the non-disclosure language could be placed in those documents. But primarily it would be under exigency, where we're actually making phone calls to providers, or we're actually physically going to a provider and asking for this information immediately because there is life danger or some sort of exigency or exception to the search warrant rule. So I feel like if we went to the third-party provider and they said there was not good cause, we would have to make a very difficult decision then whether we actually do ask for this information and do get it. We'd have to kind of weigh our consequences. What's going to happen once this is notified? Are we able to maybe accomplish our job, whatever that may be, saving the life of a child. And that if we go back to the Amber Alert, example, we would have to make a very, I guess, well-educated decision based on all the circumstances and what's going to happen once that disclosure happens. We would have to take into fact that I think once that disclosure did occur, that the reason that we were asking for that information is going to stop almost immediately. Say if it's a cell phone location, we have to, I guess, then assume that we're only going to have a few minutes once the disclosure occurs to be able to accomplish the job that we then even asked for that information in the first place. So back to your question, I guess it would be a very difficult decision. And then, yes, maybe because a search warrant under these circumstances, under the exigent circumstances, a search warrant is going to take several hours for us to accomplish and they get signed by a judge. Maybe we could get it done in 1 hour or 2 hours, but they do take time because there's a lot of information being put in those. And that is the reason for the exigent exception is we want to get this information immediately, then we follow up with a search warrant after the fact. I don't know if that answers your question.
I just, if I can ask a follow-up. I understand what the bill is trying to accomplish. I'm just, when you have a search warrant, to me, it would be the third-party provider is in the clear. It's a clear exception where they can make the disclosure. But if there's a disagreement, I suppose, amongst whether it seems that the third-party provider is the one that has to reach the conclusion, and you would be trying to convince them. But if you hit that wall, I guess my concern is that, I'm just wondering where would you go from there? Because you have these exceptions, and I think you would have to go to the warrant, but it just seems if there's an emergency, some companies may not play ball. I know that's happened before with some companies, that's why I'm asking.
Yes, I mean, I think it'd be very dangerous because every provider, to some extent, is going to be different. If we're talking about maybe the 1 or 2 person business, maybe we need whatever that may be. Maybe a gas station that has records, social security number or something. They may handle these requests and they may see good cause much differently than Comcast does or EverSource or T-Mobile that have multiple lawyers working for them. So it is going to, I think it leaves it open very widely to interpretation based on the provider.
Thank you.
Thank you very much for your testimony. Warren Cormack.
Thank you very much.
Good afternoon.
Good afternoon, sir.
My name is Warren Cormack. I'm the Assistant Attorney General who leads the Data Privacy Unit at the New Hampshire Department of Justice. I would be responsible for enforcing the statute. The New Hampshire Attorney General's office testifies neither in support nor opposition to this bill. I speak to raise concerns about its weak penalty provisions. Because the legislature will task the New Hampshire Department of Justice with enforcing HB 195, the public will expect the department to be given the tools to do so effectively and to deter the violations described in the bill. The bill provides a $1,000 penalty per violation that is so low that it is unlikely to have a significant deterrent effect on the third-party providers of information and services covered by the bill. Under RSA 507H, New Hampshire's comprehensive data privacy legislation, other data privacy violations can result in up to $10,000 in penalties per violation, 10 times what this bill provides. This $10,000 penalty amount is standard across many consumer protection statutes. Many third-party providers covered by HB 195 are exempted from RSA 507H. For this reason, HB 195 counterintuitively targets a category that includes some of the largest companies in the world with some of the weakest penalties in New Hampshire's consumer protection landscape, and in particular, its data privacy landscape. Because, as written, this statute is unlikely to give the government the tools it needs to deter and punish violators, the Attorney General's office asks for penalties of up to $10,000 per violation commensurate with New Hampshire's other consumer protection statutes and its pre-existing Data Privacy Act. Thank you.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
Does anyone else wish to testify on 195? We get another sheet, okay. What's that? Yep, I have others, but you. Sure. Can we do that? Can you? Sure. We'll send it to him. Pete will keep track. Thank you. We're long-winded too.
You're not used to coming to Judiciary, I can tell. You're not used to coming here. We're always
Today's a
behind.
long day. Well.
That's personal identifiable information right there. Now it's public.
Thank you. Robert Deitch from the New Hampshire Bankers.
Good afternoon, Chairman and honorable members of the committee. For the record, I'm Robert Dietl. I'm an attorney and president of the Gallagher, Callahan, and Gartrell Law Firm, but I'm here today in my capacity as legal counsel for the New Hampshire Bankers Association and to testify in opposition to HB 195. As I believe the senators are aware, the New Hampshire Bankers Association represents 40 member banks who employ collectively about 6,000 individuals. First and foremost, I want to say privacy protections are central to banking. It's an important aspect of banking, and our comments today are not to suggest otherwise, but there are a few points I want to raise, highlighting comments in the written remarks. First, there's been some commentary about Graham-Leach-Bliley, some questions. We're of the position that an entity-level exemption would be appropriate and needed in this legislation to avoid confusion regarding the standards set in SB 255, which does provide such an exemption. Graham-Leach-Bliley, while there's a general awareness, I think, among the committee, it provides significant privacy protections. It has comprehensive security measures, routine examinations for compliance, civil and criminal penalties. It is a robust federal standard. And there's a number of other federal laws which are cited in the written remarks that we provided to you. So that goes to my second point, which is we have concerns that absent that entity level exemption, we may end up with sort of a fragmented understanding of what the compliance obligations are for financial institutions. And I think that's exacerbated by the fact that the legislation, while it does provide language saying that there is a federal preemption in there, it doesn't specifically call out Graham-Leach-Bliley, whereas SB 255 does. And I think that creates an ambiguity going forward. That's a concern. The third point is that fraud, as you may be aware, is on the rise for financial institutions. It is a real serious problem. In my role as a private practice attorney, I frequently get phone calls from member banks of the association looking for on-the-fly guidance and advice about how to handle issues that are bubbling up in their banks. And the statute, as drafted, when I went through it, raised a number of questions, some of which have been touched on already, but which I expect would give financial institutions real pause about how to respond on the fly. And I'll point out some of the ambiguities quickly here. One is on page 2, there is discussion about a general right to provide information when a third-party provider of information has reason to believe that it's beneficial. I'm summarizing, of course. And then it goes on to section C, which talks about emergency situations and the need to obtain a warrant. Those standards are very open-ended, and I'll get questions, I'm quite confident, as to what does it mean for it to be beneficial. How does the bank make that determination, and what's sufficient to rise to that threshold? And similarly, in C, where it talks about disclosure regarding a warrant, that section of the bill arises in an area that is not explicitly in relationship to governmental requests, but the language speaks to warrants, which creates some confusion as to whether or not that actually is intended to apply to government requests. And I think that's exacerbated then when you go on to page 3 and you look at the language under part 2, which does specifically call out governmental entity requests. How do we square those and reconcile those? I'm not entirely sure right now. And the emergency language that exists generally here exists generally, if I'm understanding correctly, only with respect to physical death or serious physical injury. It doesn't reference property, and property damages or loss of property is going to be the concern in the financial world. We also have an issue, I think, potentially with this question and I won't go over it in great detail because it's already been discussed, but what is good cause under section 2 on page 3? And when a bank receives a request from law enforcement, how do they determine if there's good cause for not providing the disclosure? And all it triggers, I believe, is a request to be made and then there'll be a disclosure requirement to the individual customer. In the context of fighting fraud on the fly, where transactions move out the door of a bank rather quickly, that language is going to be very difficult, I anticipate, to work through. And another question I have, and this will be my last one, is within the section that provides the Attorney General enforcement powers on page 4, there's language that says this section shall not apply to disclosures made in good faith reliance on a court order, warrant, or subpoena, suggesting that the good faith exemption in that language only applies to disclosures that are made with process and not ones that are made under these other provisions that we've just touched on. So I think there will be a chilling effect on the ability to combat fraud if this legislation were to be adopted. And for these reasons and those in our written remarks, we respectfully would request a recommendation of inexpedient to legislate. And I'm happy to take any questions if there are any. Thank you.
Michelle, first.
Good afternoon. My name is Michelle Heaton, and I'm a representative from the Insurance Department. I'm the Director of Life and Health there. The Insurance Department does not take a position on this bill. However, there are some concerns with the way it's written. Currently, the way third-party providers of information and services is defined, it includes insurance companies. The regulatory authority to enforce this lies with the Attorney General's office, and traditionally the regulation of insurance and business of insurance and insurance companies falls within the Insurance Department. Within the regulatory structure of the insurance, we already have a number of laws that far exceed what this bill covers relating to disclosure of information, privacy of information. So we think that there would be a little bit of a conflict here as to who's supposed to be imposing or regulating what. Additionally, the term insurance companies is used, but that fails to adequately encompass all of the different entities that are involved in the insurance industry. And sometimes insurance companies use third-party administrators and various third-party entities, and they are exchanging information necessary to do their business. And it's not clear from these definitions if those entities that are working with the insurance companies would be covered under this bill or under our insurance laws. So I think there's a lot of inconsistencies with this and some of the other laws already on the books. We are also concerned that as written, the proposed regulation would require notification to the individual each time a government entity seeks to disclose personal information. That we see as a huge barrier to us being able to actually do our job. We routinely get a lot of information from our regulated entities, and this provision could cause, substantial administrative burdens. There's also a concern as to how this provision would work just in the ordinary course of conducting insurance business, specifically with paying insurance claims. Does that mean that there has to be disclosures to the consumer? Where there's a concern that's going to increase administrative tasks and burdens on insurance companies and their affiliated entities, and could really cause a slowdown in administering claims and properly servicing their insurance consumers. As I mentioned, we already do have substantial privacy protections in our insurance laws, so we don't think that this is really adding anything extra, and we are actively enforcing those provisions. We were not asked to do a fiscal note on this, but if insurance remains subject to this bill, we do think that there would be a fiscal impact. So I'm happy to answer any questions.
We're going to recess for 5 minutes. We need it anyway, so thank you.
Since Judiciary is back in session, the Honorable Representative Kirk is going to testify. I'm sorry, yes. Yes, you are.
Good afternoon, Mr. Chairman and members of the committee. For the record, I'm Neil Kirk. I live in Ware, and I'm representing myself. I'm one of the 1,340,000 people in New Hampshire who are very concerned about their privacy. I'm really offended by the idea that when I dial a telephone number, the telephone company can sell that information, not the content of the call, but the number that I call, the doctor, the lawyer, whoever it might be, without consulting me and without my permission. That's one of the reasons why I think so many folks voted in favor of the constitutional amendment, 81%, practically a record number, because we are really concerned that this information is being taken from us and used without our knowledge or permission. The constitutional amendment hasn't yet been interpreted by the New Hampshire Supreme Court, but it will be. And I don't know what kind of a case it will be. But until that time, I think it's up to the legislature to protect the citizens and give them the confidence that they expect that the information, their personal information, name, date of birth, social security number, biometric identifiers, all of that information, including telephone numbers, will not be used without their permission. And that's what this bill does. Unlike 255, which requires individuals to act, to opt out, this bill says no, that information is private unless the company that wants to use it gets your consent, or there's a subpoena and other kinds of things. The Supreme Court of New Hampshire hasn't really taken taken a position on this, although in 2005, in the case of State versus Gubitosa, they determined that a telephone number, not the content of the call, but the telephone number, could be subpoenaed by a state entity. I think in that case it was the police. But they said, the majority said, nothing in today's decision prevents the legislature from closely regulating subpoenas for phone records. And the concurrence, it was a 2-1-2 decision. The concurrence said, I would encourage the legislature to examine whether telephone billing records should be protected from the reach of a prosecutor's subpoena. This bill does not deal with that issue because it allows business as usual by all state agencies. That's the provision here. The state trooper who testified raised some valid points. You can deal with those by eliminating sections 2 and 3 on page 3. Those were the disclosure sections that he was concerned about, where good cause wasn't clarified and there were some other issues that he raised, and still get the benefit of the bill. The bill really is not trying to hamstring state activities where they're following what they're statutorily or otherwise allowed to do. What it is trying to do is to say that private companies can't take that information and sell it and use it without our permission. Enough issues have been raised today so that if I were in your shoes, I would say there are some problems with this bill. But rather than ITL it, I would ask that you consider interim studying it so that, or whatever it's called in the Senate, I'm not sure, so that some of the problems can be worked on. I'm sure Representative Lynn would be more than willing to do that, and based on some of the questions from this committee's members, there are real concerns about the issue and an attempt to understand the bill and make it better. So my request to you is that while it probably is not ready to go forward unamended, that you could seriously consider doing some work on it between this session and next session, and make sure that the privacy protections which the people of this state really expect from you are in fact implemented. Thank you, Mr. Chairman. If there are any questions, I'd be pleased to answer them.
Thank you, Mr. Chair, and welcome back, Honorable Cook. Nice to see you. Did I hear you correctly when you said that we could eliminate on page 3 lines 12 through 19 and the bill would still have its intended effect?
Yes.
That's the one section, okay. Because that's some of the section that is giving a little bit of heartburn, so that would be the Alka-Seltzer right there. Okay, thank you, that was the section I was looking for.
Thank you, sir.
Don't you normally close it on the other bill?
You're introduced.
Correct.
You know, Mr. Chair, could I just really just one point of clarification on something that was said? I really do think this is an important point.
Sure.
But I'd be very brief. I think the point with regard to first of all, I have, if this committee decides they want to, study this and work on it further, I'm more than happy to do that. But the one point I would make that I think is really, really important to understand is with regard to this disclosure of information to the person who's the object of the subpoena, bear in mind that under current law, unless you're talking about some particular federal statute, but under current law, there is no requirement. If the police go to somebody, either with a subpoena or without a subpoena, and say, for example, to the telephone company, will you give me information on me or on you or whatever? The telephone company is under no obligation not to disclose that information to the customer. They can do it or not do it, but unless somebody has a court order saying don't do it, the telephone company it's up to them. They can decide whether to disclose it or not. And so I think that my point on that is simply that to the extent that this bill in the two sections in question lays out provisions for disclosure, it actually clarifies law that is completely, there is no law on it at the present time.
There's some confusion, I think. There's another bill. Let me know. They're holding up a vote on another bill. Correct. Mine is the last bill.
That's closed. Now we're going to 522.
It's right now.
No, this one.
Sorry, that's wrong. Mr. Chair, not me.
That's okay. Okay. Who's introducing 522 for me? Representative, thank you. Representative Earth, good to see you today. How you doing?
Thank you, sir, Mr. Chair.
More privacy.
More privacy. Yeah, I've been at this for 7 years now. So, thank you, Mr. Chairman and members of the committee. I'm Representative Keith Earth, representing Ware. The simple purpose of HB 522 is to preclude government from creating or maintaining databases of people's personal information that are outside the legal requirements of the government to do so. This is consistent with our constitutional right to privacy and is intended to reinforce that right in statute. The bill most recently passed the House on the consent calendar, and in earlier forms passed the House on 2 occasions. The bill as amended provides clear definitions developed over a number of years for the meanings of available to the public, government entity, personal information, and third-party providers of information services. It clearly states, as amended, it clearly states on page 1, line 26, section Roman numeral 2, quote, unless specifically authorized by statute, no government entity shall acquire, collect, retain, or use any personal information of any individual residing in New Hampshire from any third-party provider. This concisely summarizes the intent of the bill. Most of the remainder of the bill, section Roman numeral 3 from page 1, line 29 through page 2, line 18, delineates what the bill does not apply to. This was developed over the past 3 terms in working with a number of departments of the state of New Hampshire and in listening to concerns raised in relation to municipal and county government. It clarifies that personal information collected related to law enforcement or regulatory enforcement or to subpoenas or to warrants is excluded from the bill's restrictions. It makes clear that emergencies involving immediate danger of death or physical injury or to substantial loss or destruction of property are excluded. It allows for an individual to grant permission to the state or local government to collect their information for a specific purpose. The penalty for a knowing violation is a misdemeanor, for which a person is entitled to recover damages. It makes clear on lines 24 to 25 of page 2 that it does not create a cause of action against a non-government entity. It does not impact business, but is aimed squarely at government as defined on page 1, line 9. It makes clear that federal law preempts any part of this bill. It clarifies that the exception in RSA 359-N:2, Roman numeral I, part C, related to the collection of biometric data being prohibited is extended to include the new section created by this bill. I believe we in the legislature need to take seriously our responsibility to clarify in statute what our constitutional right to privacy means with respect to the government collection or storage of information of our residents. We live in a world where individual privacy is being continually eroded. I'll take questions if it pleases the committee, but I'll note that I am not a lawyer. And there's at least one testifying that is better able to address nuances of particular legal situations. Thank you for your time.
Either way, Senator Abbott, I'll let you go first.
Thank you, Mr. Chairman. Thank you for taking my question. Can you give me an example that you've come across or at least heard of where the government is storing people's personal identifiable information without any right or law allowing them to do so? I mean, I get what you're trying to do here, but I feel like if they don't have the statutory authority to do something, they would be kind of just operating off the books in some way. I'm trying to figure out when would this apply in a realistic situation?
Well, it would apply in practice, but so thank you for the question. Can I give you a specific example? No. When I have met, as I have done with many people, from the state government, it does seem that they're generally following the law, only using the laws that they should be using to keep databases. But this is a very important point. Nothing prevents them from starting to do this. Computers are everywhere in this institution, as we all are aware, big and small. And who knows what they may or may not be doing behind the scenes. I'm not making any accusations here, but I'm pointing out this is a very simple thing to do to make clear to state government, local government, municipal government, that you can't do this. You can't build up databases on people that are just for the sake of building up databases on them. And keep in mind, it is going to get easier and easier and easier to do this. I'm a computer guy. That's what I spent my years doing. And I understand artificial intelligence because when I was in school 40 years ago, that's when it started, basically. And now that it's become powerful enough to actually look at huge databases around the world, around the state, who knows what might be done with it. So, and the intent here is very simple.
Thank you.
You're welcome. Thank you.
Thank you, Mr. Chair. Thank you for taking my question. So how would this apply to a school that is keeping information about children whose parents have provided information about their vaccine compliance? Would they have to purge this information? So, we're keeping information so that we can protect public health.
Can I answer a question with a question?
Yeah, yes.
Are they statutorily allowed to collect and maintain that data?
I can't answer that.
I think so.
Is it rules or statute? I don't.
Well, or rules.
So this would apply to rules as well?
I believe, again, I'm not an attorney.
Yeah.
Best ask that question to an attorney that's going to speak to you, but I would imagine so.
Okay, may I follow up? So I know that, I hear that you are thinking this big, but the application of this will go to very targeted spaces.
Mm-hmm.
So at the municipal level, when a municipality collects information from residents for programming, for, just collects, has information, the library has information, the rec department has information, the planning board has information. Do they have to purge that?
In my mind, again, not the
Yeah.
attorney here, are they building databases or are they just using the information on a temporary basis, like some people are signing up to play baseball? Or then are they building a database of people signing up to play baseball over hundreds of years for some other purpose? There is a distinction between making a database and simply having short-term needs of information to process something.
Okay, thank you.
You back on? Thank you very
You bet,
much.
thank you.
Who wants to go first? Neil? Bob? Whoever's going to be quicker.
Good afternoon, Mr. Chairman. I recommend Neil Kerr. I live in the town of Ware and representing myself. Thank you. What this bill does, first of all, this bill, unlike 195, applies to government only. It doesn't apply to the private sector. Number two, this bill simply puts a fence around existing government activity with respect to access to personal data from third-party providers. It does not expand that access. It does not shrink it. So anything that the government is doing, the state government, the local government is doing today, they can continue to do. What this says, basically, is they can't expand that without legislative authority. And the language that does that is page 1, line 26. Unless specifically authorized by statute, not by law, statute. Law would include regulation, practice. This is statute. No government entity shall acquire this kind of data. And then there's a whole series of exemptions. And the exemptions basically exempt everything that the state is currently doing. So there would be no change in practice by the state police, the insurance department, or anyone else under this bill. It would prevent them from going beyond what they're doing now. If the legislature at some time in the future determines that what's going on now is inadequate and wants to either contract it or expand it, that's the prerogative of the legislature. It's a relatively innocuous bill that's designed to keep the status quo and avoid further intrusions into our privacy by state government or local government. Thank you, Mr. Chairman.
Thank you. Questions? Seeing none, thank you. Representative Lynn.
Thank you. Thank you, Mr. Chair, members of the committee. I'll be very brief. I think the two prior witnesses have said most of what I would say. I would just say that I think that, as Representative Erf pointed out, this is the purpose of this bill is to not in any way prevent government from engaging in any of the legitimate activities that it engages in now, but to prevent government from engaging in, for lack of a better term, illegitimate activities. And I think Senator Abbott, you raised, I have no information suggesting that any of the agencies of government are, engaging in any nefarious collection of information. And knowing New Hampshire government pretty well, I think that we can be pretty confident about that. But it's not, I think it makes sense to have a law to implement the privacy protections in the Constitution to say, no, you can't do anything that's not authorized, that you're not authorized to do by statute. I'm old enough to remember, back in the late 60s and 70s when, for example, the FBI had their COINTEL program that was, completely sort of unauthorized, and they were gathering intelligence on Martin Luther King and anti-war protesters and, things like that. Hopefully, they're not doing that kind of thing anymore. And hopefully, at the state level, our government wouldn't be doing something like that. But I guess my sense is better safe than sorry.
Thank you.
I'm happy to answer any questions.
Seeing none, thank you.
Thank you.
Does anyone else wish to testify on HB 522? Nobody else? Nobody? Going, gone. Okay, that ends the hearing. Okay.
Do you have the old signage?
I'm sure I do. Yeah, we're just gonna do it. Senate Judiciary is back in session. House Bill 146 FN is up. The Honorable Jack Flanagan is going to introduce the legislation. Good to see you, Jack.
Same here. Thank you, Mr. Chairman. And I apologize too from my side. We got 4 bills we exec and we were behind there too. So a little story. Background, I represent Hillsborough 45, which is the flotorial of Hollis, Brookline, Mason, and Greenville. Zoning nightmare. This bill originated by a constituent who got a speeding ticket. So it's a violation. It's not, a major crime. But he wanted to fight it because he said this young state trooper was riding him like he was in road rage and claimed he was doing a speed limit that he wasn't doing. Regardless, he contested the claim. And then as time went on, when he got closer and closer to the trial date, he requested a copy of the video camera to show the behavior of the trooper. Well, the prosecutor basically said that they only keep the videotapes for 30 days and then they destroy it. Well, the trouble is that on a moving violation, you have 30 days to respond. So here it is, exculpatory evidence that he wanted to use to defend himself. And the process or the procedure that the state trooper or the state police had was that they only keep it for 30 days. So if you didn't tell them right away that you wanted the video camera of evidence, then you're out of luck. So when he went to trial and basically said, this evidence is exculpatory, and the gentleman was a smart man. He knew the process. And the judge said, well, I don't know what to tell you. Theoretically, they should have thrown out the case because evidence that he wanted, which should have been provided, was not available to him. So what the judge did was he basically said, well, the fine won't be this, it'll be that. He reduced the fine and found him guilty. And the gentleman had a place in Florida that got hit with a tornado, or excuse me, a hurricane. So he ended up saying he didn't have the time to fight it here in New Hampshire. He had dual residency. Anyway, so long story short is when I found all this information, I said, this is wrong and that they should allow the evidence to be kept in. And I had played with dates and times, whereas Chairman Roy said, no, it's a good bill. I'll make the amendment. And what we have now is the amendment that you're looking at, which is basically says you keep the videotape as long as the case can be litigated. And if it is litigated, then you must keep it till the end of the case. And I did have somewhere in my pocket, the language, but you obviously have it in front of you. But I think it was, at first when I looked at it, I was so focused on the days. But Chairman Roy did a good job by stating, no, it's based on the fact that there's ongoing litigation and it would be considered exculpatory and it should be provided. And with that, I'll answer any questions you may have. By the way, I'm sure the state police will testify that it costs too much money to store it on the cloud and this, that, and the other thing. But, that's sort of the way it works when you have a case where someone's contesting what was provided for evidence.
Sanders, yep, go ahead.
Thank you, Mr. Chair. So how fast was he going?
What did they say he was doing? Was 72. I don't know the exact speed limit. It was up near the Lakes region. But he did have his son, who is not autistic. He's Down syndrome son. So I don't think he was doing things just to go fast. I think he was not doing 72. I know the gentleman, so he's a 67-year-old man. Not to say that 67-year-old men don't speed.
Nope, okay. We're good, thanks.
All that running back and forth, and that's it.
Sorry.
Thank you for your time, and I appreciate it.
Aubrey Friedman. Good to see you today, sir.
Mr. Chairman, committee members, Aubrey Friedman. I live in Bridgewater. I speak in support of this bill. So when you get stopped for even a parking ticket, those usually are people will just pay them, but they can be contentious. And so it's good to have a record of what happened if it's available. Now, if they tape it and then they delete it, so that doesn't help anyone. So this is kind of, in my opinion, a transparency thing. Keep the stuff for a while. It doesn't do any good if you don't have it available. Also, if it goes to court, this would actually protect the law enforcement officer and the member of the public. If there's a dispute about, it got ugly or whatever it is, the court could see the actual evidence and wouldn't have to rely on hearsay or conflicting views of what happened. And lastly, this issue, when I first read the bill, I thought, gee, this is going to be a lot of extra storage cost to, there's like millions of traffic stops, so it could be like, but actually, you look at the fiscal note, it's under $10,000 per year, which for the state, that's nothing. And normally, I'm fiscally conservative. I don't want any extra state, if it's wasteful. But in this purpose, I would say it's a good thing. It's better to have more transparency and have it available when you need it. So I would say the benefit exceeds the cost in this case, and those are the reasons I support the bill. Thank you.
Thank you very much. Any questions? Seeing none, thank you for attending today. Major Davey. Good afternoon. Thanks for your patience with us.
Good afternoon, Mr. Chair and members of the committee. I appreciate your hearing testimony. The Department of Safety's stance on this bill as written is to oppose it. And as the sponsor noted, cost is a factor in that opposition. What this amounts to is an unfunded mandate with cost per terabyte being fairly extensive and only increasing over time. Yes, these costs they are being, and they will continue to be borne by the state of New Hampshire without question. I would submit that to expect other agencies, particularly small law enforcement agencies that wish to engage in the use of body-worn cameras, to have this requirement made of them is to potentially to put such a program out of risk or out of reach for them financially. Furthermore, as written, this bill has unintended consequences in that, just for example, with the state police, somewhere in the order of 10,000 traffic summonses are issued annually, and they go into the ether. Because they are violation level offenses that bear no risk of incarceration on the part of the accused, they're not tracked like our misdemeanor cases are. They don't wind up in our report management system with the same footprint. They do exist there, but in a much lesser way. And as far as case management practices are concerned, what this bill will do, as written, is require troopers to take hundreds, maybe 1,000 or so annually traffic summonses that they issue, and then have to treat those as they treat misdemeanor cases that bear the risk of incarceration. To track them, to do final dispositions on them, to effectively, as we would do with a motion to dispose and other evidence, be sure that the risk of further adjudication is no longer. And that is, as it turns out, a very difficult thing to do, because if a person fails to appear for a traffic summons and they're found administratively guilty because they either absented themselves from the state or just didn't feel like going to court that day, they'll then be sent a notice. They may not receive it. It is not beyond my experience and the experience of others who wear my uniform to have people reappear after years of absence, and because of administrative issues, fines, defaults, things that they need to clear up, they seek to effectively re-litigate the cases against them. So what that produces then is no end date. I would propose actually that it would be a far more workable solution, although the sponsor spoke to this and his reasons for going in a different direction, would be to put a short timeline on it. These are violation level offenses. They're strict liability offenses. Furthermore, what we're talking about here is body worn camera video. I could show you hundreds of my own stops, even though that's not what I do primarily anymore, that will give you fantastic views of my steering wheel and my hands and evince nothing about the conduct of the driver. They could evince that I behave professionally or perhaps not professionally. The interactions can and do quite often because people don't like to be interrupted and told they've made a mistake. They're having bad days and they get worse when they meet us. So there certainly can be contentious discussions, but the case at bar before a court in these matters is whether or not the defendant violated the law in a strict liability offense. And as I've explained to a lot of people, what that means is it doesn't require that you meant to do what you did or even that you knew that you did was a violation of law, but that you did it. Furthermore, it continues to diminish the value of testimonial evidence offered at trial for law enforcement, which effectively raises the bar on the proof that an otherwise credible officer needs to clear in order to convince a judge that a person violated the law and ought to be held to account for it. For all of those reasons, the Department of Safety stands in opposition to this bill. Furthermore, and lastly, a defendant has 30 days within which to answer a complaint. My understanding of the way that the court system works, the way that hearings are triggered, is that it really wouldn't take much more than that if the law were tailored in such a way that 60 days were the minimum retention period for any recording or any motor vehicle violation, even if you wanted to get specific. I think very rare would be the person who would plead not guilty, even if they waited all 30 days and we got the notice, that we wouldn't still have the video, notwithstanding that errors do occur. So that concludes my testimony. I appreciate your time.
Thank you very much for your testimony. All set? All set. Thank you.
Thank you very much.
Jack, I never let people go twice, and I've done it twice today. But sure. I'll give you 1 minute, Jack. I never let people go again.
That's okay. Thank you. You do realize that if the evidence helped the prosecution, meaning the.
I'm all set unless
No,
you had
but
something.
I'm just saying is it would be saved.
Okay, thank you,
Okay?
Jack.
That was it, brief, huh?
Thank you.
And the 60 days is okay too.
Does anyone else wish to testify on 146? Seeing none. Ends the hearing. We're not going to exec anything today. No, ma'am.